Court does call the case of the people versus Cody Jolly. Your name, sir?
Cody Lee Jolly.
All right. I think this is people's motion.
Yes, Your Honor. I'm handling this for Ms. Willenbring. There is sensitive information in the police report that includes victims' contact information at home addresses and birthdays. So pursuant to the court rule, Ms. Willenbring would like to redact that information from the police report, but is requesting order from the court for that effect as well.
All right. First thing, Mr. Jolly, let me just, you are going to continue to represent yourself, sir?
Yes.
All right, I just want to.
Right out of the gate, this case takes a risky turn. The defendant is choosing to represent himself, and in criminal court that's rarely a power move. Judges allow it, but there's no safety net. No shortcuts, no coaching, no mercy for mistakes. One wrong move here can cost years of freedom.
You that you are charged with that there are 2 counts on your complaint of criminal sexual conduct in the fourth degree by force or coercion. You understand that, sir?
I understand what the charges are, but never.
Okay. Sir, I have to advise you.
Okay.
You understand that?
I understand.
And that those are high court misdemeanors punishable by up to 2 years incarceration or $5,000 fine plus court costs, mandatory HIV and STD testing.
Okay.
You understand that, sir?
Yeah.
All right. Sir, you wish to continue to represent yourself. The court does have to just advise.
Let's pause here because this is serious. 2 counts of 4th degree criminal sexual conduct by force or coercion may sound technical, but the consequences are brutal. Possible jail time, heavy fines, and mandatory medical testing. This isn't a paperwork problem. This is life-altering territory. Would you gamble with charges like this without a lawyer?
That I will hold you to the same standards as I would hold somebody that is licensed. You have to abide by all of the court rules, etc. You understand that? All right. And that you won't get any favoritism, and that the court is not in a position and will not assist you if there is something that you don't understand. You are going to be charged with knowing court rules and procedure. You understand that?
But I do.
All right. And I would ask you, or I would also tell you that you do have the right, and if you'd like an opportunity to consult with either a retained lawyer or somebody from the public defender's office, the court would make that occur.
Okay.
You understand that, sir? Okay. Do you have a response to the motion from the people?
I mean, my understanding then is they're going to retract the name, the identification of them, but I'll get the rest of the information. Is it correct?
You would get the rest. My understanding is any identifying information other than name,
Okay.
like address, any phone numbers, anything along those lines would be redacted. Do you have any problem with that, sir?
No, I have no use for that.
What I would indicate is that I will grant the motion as filed by the people.
Okay.
And there's also a request, I guess, that the motion hearing will be sealed and preserved for review in the result of an appeal.
I mean, yes, because that's what the court rule says. It's a funky court rule.
It is.
Because I haven't said their addresses or phone numbers out loud. It's just like the court rule says that if we're going to redact, that this hearing then becomes sealed.
Yes, it does. It does say that. So, I mean, I'll order it because that's what the court rule says. However, none of that information has been provided on this record. So the record is clear.
This part might sound boring, but legally it's huge. When a hearing is sealed, the public can't see it, the media can't review it, and everything is locked away for appeals only. Courts usually do this when privacy and liability are on the line. Translation: the stakes just quietly went up.
Okay, I have a question, Your Honor. Like I said, I have no awareness even of an incident or any conflict occurring at all. I've been obedient on I've been good on the tether so far. I talked with Brandon Casey, there, my case manager across the street. He thought that I wouldn't have a problem getting off after the first 30 days here.
I'm sorry?
The tether that I have, I mean, I'm a member, I haven't been in trouble, you know, where I've been here for years. I don't have, you know, something to fight, but
So what are you requesting?
that I get this tether off. It's over. It's only fair. I mean, you know, I've not been in trouble at all in Ann Arbor ever since I've been here. I've been in trouble at all. Not on probation. I have nothing to do with being a trouble to the community at all or anything like that. No witnesses here. So this is just, you know, we grant that, please.
Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything.
Right, exactly.
I'm
Probably
going-
cause or anything.
And there it is, denial. No tether removal, no relief. From the defendant's perspective, that feels personal. From the court's perspective, it's about risk management and public safety. This is where frustration meets authority, and that's a dangerous intersection.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear.
And here,
This is the moment the tone of the case changes. It's no longer about conditions or paperwork, it's about control of the courtroom. Judges will debate law all day, but they do not tolerate emotional explosions. One bad reaction can turn freedom into handcuffs instantly.
I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me?
That warning wasn't dramatic, it was procedural reality. Self-representation means you don't just fight your case, you manage your behavior like a lawyer too. One mistake, one outburst, and the court can legally take your freedom before the trial even begins. Court isn't just about being right, it's about staying disciplined.
If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.